4, the interests of justice do not permit the release from detention of an applicant or applicants where one or more of the grounds referred to in section 60 subsection 4A to E are established. The granting of bail will depend mainly on whether the applicants applying for bail are likely to do anything which may prejudice the interests of justice. Each of the 5 grounds referred to are further developed in section 60 subsection 5 to 60 subsection 8 capital letter A and 60 subsection 9, which contain an extensive and detailed list of the potential factors for and against the granting of bail, to which this court must have consideration to, so to establish where the interest of justice lies. In considering the question in section 60 subsection 4, the court shall decide the matter by weighing up the interest of justice against the rights of the applicants to their personal freedom and in particular the prejudice that they are likely to suffer if they are detained in custody. Evidence may be adduced either by way of viva voce evidence or by way of sworn affidavits. All the applicants elected to adduce evidence by way of sworn affidavits. Such affidavits on behalf of the applicants 1 to 10 were read into the record, confirmed by applicants as true and correct, and marked Exhibit A, B, C, D, E, F, G, H, I, and J, respectively. No documentary evidence or witnesses were called on behalf of any of the applicants, whereafter all the applicants closed their application. The state thereafter proceeded to address the court from the bar as to the reasons for not opposing bail in regard to all the applicants before court. In this regard, the state made reference to the applicants' personal circumstances, their criminal profiles, the strength of the state's case, and how each applicant was linked to the alleged offences. The state then closed its case. Ms. Kuleli, for applicant 4, replied to the state's case, which reply was intertwined with the heads of argument. All the attorneys then addressed the court before judgment, submitting that they would be able to afford the bail amount suggested in the affidavits, that the court has to be cautious not to set to a high amount which applicants could not afford, as it would tantamount to effectively denying bail. Applicants further submitted that the state was not opposed to the release of the applicants on bail. Further, that the applicants were not flight risks, and that they would not intimidate or influence any witnesses, as the witnesses are unknown to them. It was further submitted that the state's case against the applicants were weak, setting out individually the reasons for subsubmissions, and that taking the above into consideration, that there is no likelihood shown from the state side that any of the factors setting out in section 60 subsection 4A to E could be found to be applicable in the applicant's applications. It was submitted that all the applicants rebutted the onus on them, and thereby proving that it would be in the interest of justice to grant them bail. The state thereafter addressed the court before judgment and referred to how far the investigation was, the further accused. Indeed, that further accused will be added, and setting the record straight in regard to the amounts of tenders involved, which amounted to over 1 billion rand. The state further suggested bail conditions and proposed bail conditions to the court. Now, due to the fact that this bail application is to be dealt with as a Schedule 5 bail application, the court is guided by Section 60, subsection 11b, Act 51 of 1977, which states as follows, and I quote, "Notwithstanding any provisions of this Act, where an accused is charged with an offence referred to, subsection B, in Schedule 5 but not Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduced evidence which satisfies the court that the interests of justice permit his or her release. The onus rests on the applicants to prove that they have made out a case for their release on bail. The ordinary standpoint is that accused people charged with Schedule 5 or 6 offences are to remain in custody unless the onus is discharged. The burden of proof on the applicants are to be met on a balance of probabilities. Ordinarily, one would determine the factors contained in Section 60, subsection 4a to e, read with Section 60, subsection 9, to determine whether the interest of justice is met in the release of the applicants. In State v. Dlamini, Dladla, Joubert, Skietekat, the following was said, and I quote, "This view is strengthened by a consideration of Section 60, subsection 11b. Such subsections stipulate that the accused must satisfy the magistrate that the interests of justice permit his or her release. It clearly places an onus upon the accused to adduce evidence. However, apart from that, the exercise to determine whether bail should be granted is no difference to that provided for in subsections 60, subsection 4 to 9, or required by Section 35 1F. It is clear that an accused on a Schedule 5 offence will be granted bail if he or she can show merely that the interests of justice permit such grant." Now, that is according to paragraph 65 of State v. Dlamini. In regard to the interests of justice, Section 35, subsection 1F of the Constitution of the Republic of South Africa states the following, and the court quotes, "Everyone who is arrested for allegedly committing an offence has the right to be released from detention if the interest of justice permits, subject to reasonable conditions." In State v. Dlamini case supra, it was elaborated in paragraph 6 in regard to Section 35 1F. Section 35 1F in its context makes three things plain. The first is that the Constitution expressly acknowledges and sanctions that people may be arrested for allegedly having committed offences and may be, for the reason, be detained in custody. The Constitution itself therefore places a limitation on the liberty interest protected by Section 12. The second is that notwithstanding lawful arrest, the person concerned has a right, but a circumscribed one, to be released from custody subject to reasonable conditions. The third basic proposition flows from the second and really sets the pattern, the normative pattern for the law of bail. It is that the criterion for release is whether the interest of justice permits it. What that term means, both in the Constitution and in Section 60 of the Criminal Procedure Act, is central to much of the judgment and will be thrashed out later. All that needs to be said at this stage is that Section 35F postulates a judicial evaluation of different factors that make up the criteria of the interest of justice, and that the basic objective traditionally ascribed to the institution of bail, namely to maximize personal liberty, fits snugly into the normative system of the Bill of Rights. It is accordingly important that the rules of that institution, which are set by some to be at odds with that values, be scrutinized systematically." End quote. When looking at the interest of justice in considering the grounds in Section 60, subsection 4, there needs to be a likelihood established, as correctly submitted by the legal representatives present, that the applicants would engage in certain conduct should they be released on bail. The section requires the court to consider the future action of the applicants. In State v. Sabalala, 1992, Volume 2, SACR 259, Cape High Court, case page 269, it was held, and the court quote, "It is true, furthermore, that the court must assess the applicant's future conduct in light of existing or historical factors and circumstances." Now, paragraph 49 of State v. Dlamini in this regard states the following. It remains a unique interlocutory proceedings where the rules of formal proof can be relaxed and where the court is obliged to take the initiative if the parties are silent, and the court still has to be proactive in establishing the relevant factors. More pertinently, the basic inquiry remains to ascertain where the interests of justice lie. In deciding whether the interests of justice permit the release on bail of an awaiting trial prisoner, the court is advised to look to the 5 broad considerations mentioned in paragraph A to E of subsection 4, as detailed in the succeeded subsections. And it has to do the final weighing up of the factors for and against bail as required by subsection 9 and 10. Subsequently, section 4, 9, and 10 of section 60 should therefore be read as requiring of a court hearing a bail application to what court have to do in balancing the said factors. In this regard, it is as well to remember, it's good to remember that section 351F itself places a limitation on the rights of liberty, dignity, and freedom of movement of the individuals. In making such evaluation, the arrestee therefore does not have a total untrammeled right to be set free. More pertinently, that in the past, the court is now obliged by section 60, subsection 2C, 3 and 10 to play a proactive role, and is helped by subsections 4 to 9 to apply its mind to a whole list of factors potentially in favor or against the granting of bail. Now, the reasons why the applicants wish to be released on bail. Applicant 1. Applicant 1 indicates in his affidavit that he lives in Ngobo in the Eastern Cape, and he has a fixed address. He has 6 dependents. He's self-employed, running his farm in the Eastern Cape where he employed employees. That he is alleged first offender in the sense that he doesn't have previous convictions. He is a citizen of South Africa. He has no history of absconding court proceedings. He has dependents who is depending on him. And further, he has submitted that his passport was taken by the police during his arrest. The state, furthermore, according to his affidavit, does not oppose his release on bail, and that he will adhere to any bail conditions set by the court. He can, according to him, afford 5,000 rand, and that will be paid by his family. In regard to applicant number 2, she lives in Grassy Park in the jurisdiction of this court, which address was confirmed by the state. She has 2 dependents. She is employed at Glomix, being an accountant clerk. Her roots are with the court's jurisdiction in the Western Cape. She's not a flight risk. She has dependents, and her incarceration furthermore will affect her employment. She can afford 5,000 rand bail, which will be paid by her family. She indicated that she has no pending cases. She indicated, that she does have 1 pending case, and that's for the obstruction of justice. However, was released on bail in that matter. She hasn't stated anything in regard to her passport in the affidavit. Third applicant, he lives in Mitchell's Plain in the jurisdiction of this court, which address was confirmed by the state. He has 2 dependents. He is employed as a cleaner. His route is within the Western Cape, has a fixed address. He has a clean record. He's not a flight risk. He has 2 dependents, and he will adhere to bail conditions. He can afford to pay 2,500 rand, which will be paid by his family. In regard to the 4th applicant, he has a fixed address in Gauteng, which address was confirmed by the state. He is self-employed, being a director of 4 companies, being Boon Africa, Imali Corp 202, Boom Group, and Sigma Energy, which, according to him, are currently not generating any revenue. However, the court notes that no proof of him being a director of the said companies, any documentations to show past income in either way of his accounts or accountants, bank statements, or even SARS documents, and how it is or have been decreased, was placed before this court as proof to his aversion that his company's revenue is basically totally deteriorated. He owns property in Modderfontein in Gauteng. He is married with 3 minor children who is dependent on him, and further that he has a clean record. He is a sole breadwinner of the family. Applicant 4 denies the allegations against him. He is not a flight risk. The applicant has a valid passport, was handed into the investigating officer, and can afford 5,000 rand, and not stating how he got to the said amount, and he will adhere to bail conditions. 5th applicant has a fixed address and lives in Stellenbosch, which address was confirmed by the state, is married to applicant 6 and has 2 children, employed at R.J. Mullins Civic CC, holding 49% shares, and runs his business every day, has a clean record. His roots are in Cape Town. He is alleged first offender, clean record, not a flight risk. The state further is not opposed to his release. His employees will suffer as well as his business if further incarcerated. Also can afford 5,000 rand. Court also note that nothing was attached to the affidavit indicating the registration of the closed corporate, what this corporate entails, what is the financial status of this business that he has got a 49% shares in. Applicant 6 also lives in Stellenbosch in the jurisdiction of the court. It was address also verified by the state, married to applicant number 5 and has 2 children. She's self-employed in the same company, R.J. Mullins Civics CC, and holds a 51% shares and runs this business on a daily basis. She has a clean record. Her roots is in the Western Cape, and she is an alleged first offender. She has dependents who relies on her, including the employees of the business. Again, nothing to substantiate that she's got employees or whether this closed corporate is viable, and if so, what is the income and what is the expenditure, to give an indication to the court as to, and I will deal it when I come to the amount of bail requested, as to getting the court to decide that 5,000 rand may be sufficient, which will also be paid by her families. We'll adhere to bail conditions as well. Applicant 7 lives in Centurion, Gauteng, which address was also confirmed as being a fixed address, has 3 dependents, self-employed at New Generation Corporation Group, of which he is the owner of. Again, same. It is noticeable that all the applicants, with the exception of applicant 8, just gave in an affidavit which was clearly a pro forma, filled in here and there, but nothing to prove. It's about providing evidence. Why? To satisfy the court that it would be in the interest of justice to grant bail. Playing open cards is vital at this point in time. Let's move to applicant 7. As mentioned, 3 dependents, self-employed, no proof of the New Generation Corporation Group, what it entails, how much it's made, what the situation is, has a clean record. She's an alleged first offender, citizen of South Africa, not a flight risk, was arrested at her address, and she is a business owner and stands a risk of losing money if further incarcerated. There's no proof to that. The state is not opposed to bail. Another reason why she wants bail, she will adhere to bail conditions, and 2 can afford 5,000 rand payable by family. Eighth applicant. She lives in Sandton, Gauteng, which address was confirmed. She's employed as an information technology executive at Zamele Technologies in Johannesburg, filling a senior position. If she should, according to her, be denied bail, there would be no other person that could fulfill her role in the company and will affect the profitability of the company. Again, no proof being employed, no proof of the fact that she fills this position, no proof of what her work actually, employment actually entails. And I will deal with the bail conditions suggested or requested by your attorney, Mr. Mathewson, previously. She earns roughly about 100,000 Rand per month. She sustains herself and her family with her income, and she's got no children. Her mother suffers from hypertension and diabetes, and she is responsible for medical aid and contribute about 8,000 Rand. She also assists her brother, though self-employed, with groceries if necessary. She fears for her health due to the bad conditions in Polsmore Correctional Facility, which included her mental health, and this might result in depression. She's anxious and foresees further that should, if denied bail, her feeling anxious will accelerate and it may be worsened by the actions of the inmates which she would share a cell with. South African prisons are overcrowded. Conditions in the prisons is a breeding ground for disease and infectious diseases. Taking the submissions of applicant number 8 into consideration, the court is mindful of the following case law: State versus Van Wyk, 2005, Volume 1, SACR, in brackets 1, appeal court decision. The accused's health deterioration, and he deteriorated in this matter, and he indicated that he will suffer from furthermore because he has diabetes and high blood pressure, and he did not receive medication. That was Van Wyk's case. The court held in that case, and I quote, Applicant het ander regsmiddele tot sy beskikking en is borg in die algemeen nie die remedie vir die vergrype en versuime van die gevangenes owerhede nie. Close quotation, indicating that the applicant in such a situation has other legal avenues to follow, and this is not the way or the avenue for the court to decide on. In Solomons versus S 2019, bracket 2, all 833 WCC, Acting Judge de Waal held as follows in the court, quote, I do not believe much can be made of the conditions of detentions in a case such as the present one. Whilst unsatisfactory, I believe that conditions of detention is really a separate issue which needs to be addressed through the office of the inspecting judge or some other process. In Bardense and another versus S, in brackets 2023, then 3, all SA 381, High Court decision in Cape Town, Judge Van Zyl indicated, and he stated, the court quote, this is for obvious reasons. If bail was the appropriate remedy, every single accused person would be entitled to be released on bail on the conditions prevailing in the prisons. Applicant 8 further in her application indicated the following, that she has no immovable assets and her movable assets are at a residential address, which includes 2 Mercedes Benzes. She has a valid passport and is willing to surrender it to the detective. She actually did during the law proceedings, but according to what she stated in her affidavit, but stated that she needed it for her employment and will adhere to bail conditions in that regard. If incarcerated, she would not be able to make a living and not look after her elderly mother. She is furthermore, according to her, the breadwinner in the family. She further submitted that she might lose her employment if further incarcerated and will affect her family financially. Further, if incarcerated, it might lead to her mother's health deteriorating due to worrying over her. She also undertook to abide by any bail conditions. She would be able to pay an amount of 2,000 rand, which her family will pay. Ninth applicant. Ninth applicant, she lives in Germiston, Gauteng, and this address was confirmed by the state. I'll just double check something. Right. There's one child that's been looked after. She's employed by Mapei Enterprises as a financial administrator. Has a clean criminal record, not a flight risk, passport. According to the affidavit, she does have a passport, and it is submitted, will be submitted to the state. Furthermore, the applicant wants to continue with her employment, support the minor child, which depends on her, and state is not opposed to bail, will adhere to bail conditions, can afford 3,000 rand. Last applicant, 10th applicant, lives in Edgemead, in jurisdiction of the court, which address was also confirmed. Married with 3 children, she's unemployed, she has a clean record. She gave herself over to the police. She and her husband support her younger brother, as her parents are deceased. Will also adhere to any bail conditions, and her husband is prepared to pay 10,000 rand. Now, the reasons for not opposing bail, according to the state, are as follows. 1, all the applicants have fixed addresses, and it was confirmed that all the applicants' passports were handed to the investigating officer, of which applicant 8 handed her passport to the investigating officer on the last appearance. That the state is of the opinion that strict bail conditions would and will secure the tenants of the applicants. He also handed up suggested bail conditions. In regard to the investigation, it was submitted that all the witnesses already made statements, that further accused would be added to the charge, which evidently would lead to further investigations. The state then rectified the following submissions in that the amount of tenders initially quoted were 11, but it's actually 8, and the amount involved then was 850 million, which is in fact 1.062 billion rand. The state then broke down the relevant tenders and the amounts. Application of law to the facts. All applicants, as mentioned, have produced evidence in the form of affidavits. The state did not produce any form of evidence, either by way of an affidavit or viva voce evidence. However, elected to address the court from the bars mentioned before, which does not constitute to evidence placed before court. It is tried that a court assessing an application for bail must holistically determine whether the applicants have discharged the onus incumbent on them. Section 60, subsection 9 states the following. The court quote, in considering the question in subsection 4, the court shall decide the matter by weighing the interests of justice against the right of the accused to his or her personal freedom, and in particular the prejudice he or she is likely to suffer if he or she were to be detained in custody. It is further tried that the use of an affidavit carries less weight than viva voce evidence that is open to test by cross-examination, and here the court refers to State v. Pienaar, 1992, volume 1, SACR 178W, page 180H, which was confirmed in the Peel Court case of State v. Matebula, 2010, volume 1, SACR 55, which states at paragraph 12, he found that the attempt upon affidavit evidence not open to tests by cross-examination and therefore less persuasive. The court is also mindful of what was held in Killian v. S. in brackets 2021, close bracket, capital letter ZAWCHC 100, and that judgment was given on the 24th of May 2021, where it was held that, and the court quote, bail applications is sui generis To an extent, they are inquisitorial, and in general, there is no prescribed form for introducing evidence at all. But in cases where Section 6011 applies and there is consequently a true onus on the applicant to prove facts, an applicant would be well advised to give oral evidence in support of his application for bail. This seems to me to flow because, differing from the position in which the Plaskett-Evans rules is applied, the discharge of the onus is a central consideration in Section 6011 applications. If the facts are to be determined on paper, the state's version must be accepted where there is a conflict, unless the version appears improbable. Close quote. In this bail application, only the applicants adduced evidence in the form of sworn affidavits, which means that the court only has the evidence under oath from the applicants. Each case are being assessed on its own, and so to determine whether in a particular case the use of affidavits was sufficient to discharge the onus placed upon the applicants. Due to the fact that the state did not adduce evidence, either by way of affidavit nor viva voce evidence, if applied, keeping in mind the Killian case I've just read out, it is clear that the only evidence before the court that tantamounts to evidence is that of the applicants. The interest of justice will not permit the release of applicants on bail if one of the more of the following factors have been established. 60 subsection 4a. Where there is a likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offence. Or B, where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Or C, where there is a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses, or to conceal or destroy evidence. Or D, where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. E, where in exceptional circumstances there is a likelihood that the release of accused will disturb the public order or undermine the public peace or security. Now, focusing on Section 60 subsection 4a, it needs to be read together with Section 60 subsection 5. In this regard to all the applicants, no evidence was placed before the court that any of the applicants have been convicted previously, nor that they have outstanding warrants. Applicant 1, 3, 4, 5, 6, 7, 8, 9, and 10 all have no pending matters, with the exception of applicant 2 that has a pending matter which is out on bail of 10,000 rand. It was submitted that the pending case is interlinked to this charge and will be joined as one. Further, no evidence was adduced that any of the applicants are a possible danger to the community. What has been submitted is that all the applicants indicated that due to the fact that no evidence was placed before the court in this regard, that clearly this is not applicable to them. Section 60 subsection 4b must be read with Section 60 subsection 6. In this regard, the court looks at subsection A, which finds application, which is the emotional, family, community, or occupational ties of the accused to the place at which he or she is to be tried. This was set out in the respective applications which are already dealt with, and the court refers to what was already then placed in regard to the said subsection. The assets held by the accused and where such assets are situated. Subsection B finds application regarding to applicant 1. You have a farm in the Eastern Cape, fixed asset. Applicant 4 has property situated in Modderfontein. Applicant 8 has got movable assets. Subsection C finds application, that's the means and travel documents held by the accused which may enable him or her to leave the country. In this regard, it was submitted by all the applicants via their legal representatives that there were no evidence placed by the state to suggest such likelihood, as all the applicants handed over their respective passports to the investigating officer. Now, Mr. Mathewson for applicant number 8 submitted that his client would surrender her passport to the investigating officer, but requested that when needed to travel outside the borders of South Africa for work purposes, her passport be made available to her, on which she undertake to supply the investigating officer with the relevant flight details, itinerary, including her return ticket. Now, the state did not elaborate in their address before judgment in regard to this said request from applicant 8. The court, however, keeps in mind the following case law which finds application. In Novella versus S, in brackets, capital letter A 340/16, that is 2016 case. Capital letter ZAWCHC 141, 12 October 2016, it was held by Judge Lepranse in paragraph 28, and the court quote, "The retention of the applicant's travelling documents is also of cold comfort, as the lack of travel documents in recent times is hardly a deterrent to persons who are serious and have the means to skip the country. Experience in courts have shown that these documents can readily be obtained and one may depart the country with ease." The court will return to the request made by applicant 8 shortly. Subsection D finds application. The extent, if any, to which the accused can afford to forfeit the amount of bail which may be set. Now, in regard to applicant 1, he indicated in his affidavit that he is self-employed, running his farm in the Eastern Cape, in Gobo, where he employed employees. Again, I touched on it, there was no proof of income, either in the form of a bank account, what your income, your expenditure was, what the payments to your employees are, nothing. So the question, when applicant 1 indicated that he can afford the amount of 5,000 Rand, which is not going to be paid by him but by his family, there was no indication as to where he gets this amount from. Regarding applicant 2, she's employed at Glomix, being an accountant clerk, as mentioned, also did not stipulate nor present any proof in the form of a salary slip or a bank statement to show the salary she was earning and what it tantamounts to. Also, just give an amount. I can afford 5,000 Rand payable by my family. The applicant did not elaborate how she came to this figure, as no proof, as mentioned, was submitted attached by the affidavit. Applicant 3. He is employed as a cleaner, did not specify where, nor proof of his income, what it was, payslip, bank account, where it was paid in, nothing. Same here, can afford 2,500 Rand, payable by his family. The applicant too did not elaborate why he suggests this amount and why the court should find that it is suitable in the circumstances of this case. Applicant 4. Self-employed, being a director of 4 companies, as mentioned before. Again, also, court note, no proof of him being a director, as touched on previously, no indication or bank statements or any statements from his accountants showing that his businesses were deteriorating, that in effect it's not basically viable. That was a submission in your affidavit. And also, did not indicate where the applicant get the amount of 5,000 Rand from, that the court must just grant. Going to applicant number 5, same, already touched on it. It's a shareholder, 49% shareholder in a closed corporate. no documentary evidence placed before court. What is the income of this close corporate? What is the expenditure? What is the income? And the same goes for applicant number 6, as they are married. Also can afford 5,000 rand each. Applicant 7, employed at New Generation Corporation. Also, where's the letter of employment? What position applicant is? What is the income? Where's the payslip? Where's bank? Where's expenditure to say, yes, I earn, like accused number 8, applicant number 8, played open cards with the court, indicated that is more or less her income. Indicated where her money is going to, helping the elderly mother, paying for medical aid, helping the brother, got Mercedes-Benzes. This is important, that once you're in a bail application that you play open cards. It helps the court to also ascertain the genuineness of the applicant's applications before court. None was done. In regard to applicant 8, I think I've indicated already there as well, there was not any proof in the form of a payslip or your position, especially when requested for leaving the country, flying in and out, and that your company will lose money, as you indicated in your affidavit. In this regard, 2,000 rand bail. Now, also, no proper set out of where the money goes to and why you're supposed to indicate to the court that 2,000 rand will be sufficient. Applicant 9, same. Employed as a financial administrator, also no salary slip, no bank statement, no income expenditure. Can afford 3,000 rand, payable also by the family. Applicant 10, unemployed. Clearly, she cannot afford bail unless her husband assists. He indicated that he can afford 10,000 rand. The court is in the dark where this husband of applicant 10 is working. What is his income? What is their expenditure? Where do they get to the amount of 10,000 rand, which would be sufficient in this bail application? It is tried that the courts are entitled to fix huge amounts of bail where the accused is clearly a man or woman of vast financial resources. In terms of section 60 subsection 2 capital letter B, small b, and then Romans 2, the sum of bail must be appropriate in the circumstances. In State versus Fetani, 2007, volume 2, SACR 590 appeal court decision, the Honorable Judge Jafta at 110 indicating fixing bail at an excessive amount in a case involving a poor person, such as was the case where he presided over, presents and at the end of the day tantamount to a refusal if it is too high. The court should endeavor to fix bail at an amount which not only can be paid but which will make it more advantageous to the accused to stand trial rather to flee and thereby escheat his or her bail. In State versus Mabolombo, 1995, volume 5, BCLR 614, Cape Division, the court held that in determining the amount of bail, the court can also entertain the possibility that the accused is still in possession of his or her share of the spoils of the crime. The ability to pay bail is not the sole criteria in determining the amount of bail. The court should guard against fixing a so-called nominal bail. In State versus Jacobs, 2011, volume 1, SACR 490, in brackets ECP, Judge Roberts observed at paragraph 19, and the court quote, bearing in mind that the purpose of paying a sum of money is an incentive to an accused to stand trial, a nominal amount does not fulfill that purpose to the accused of little or no means. Any amount of bail practically means no bail when this person does not have enough money to pay bail, and it's excessive. To a man of vast financial resources, fixing of a nominal amount of bail has the undesirable effect that the amount of bail is not seen as an inducement to stand trial, and therefore generally detracts from the seriousness in terms of which release on bail should be considered. With reference to Lynn and another versus S 2021, Volume 2, SACR 505, WCC 22 February 2021, it was held by the court. Bail is a method to make sure that an accused person comes back to court. People post cash which they should forfeit if they flee. Definitely, it's not something unheard of that many people have failed to appear in court after paying bail, notwithstanding the fact that they stand to forfeit huge amounts of bail monies. Now let's move on to subsection I, which also finds application. That is the binding effects and enforceability of bail conditions which may be imposed and the ease which such conditions may be breached. It was submitted by the defense that the applicants will adhere to strict bail conditions, and the state echoed that the state does not have objection if there is proper strict conditions, and submitted a proposed draft of such bail conditions to the court for consideration. Now the applicants before court rely on State versus Bronco and State versus Bennett, and the court will therefore indicate what it was held. A court should always consider suitable conditions as an alternative to the denial of bail. Conversely, where no conditions is given to the application of suitable conditions as an alternative to incarceration, this may lead to a failure to exercise a proper discretion. In Bennett, the court also held that bail can be granted. To safeguard the conditions, the court should, if possible, lean in favor of doing so, and even though the court is of the opinion that there is a reasonable possibility of interference with the investigation, nonetheless, to the extent that there is a risk, this can be met by suitable conditions. Subsection G finds application, and that is the strength of the case, the state's case. The strength of the case against the accused and the incentive that he or she may, in consequence, have to attempt to evade his or her trial. Indeed, the state did not produce evidence, but addressed the court as to the charges and how the applicants are linked. The applicants did not deal with the merits of the state's case in their affidavits. Suffice to state during their respective addresses before judgment via their legal representatives indicated that the state's case is weak. The state did not even go really into the merits of it. But what they have, they indicate that this indeed is a weak case. Now, the following found application in the law. Maboho versus Minister of Home Affairs 201 JDR 1014 LT. Argument is not evidence and is not under oath. It is merely a persuasive comment made by the parties or legal representatives with regard to questions of fact or law. Argument does not constitute evidence and cannot replace evidence. At this point in time, all applicants deny any involvement, which basically boils down to a bare denial, which, if going on a trial stage, is not a defense in law. The court then further goes to section 60 subsection 4c, which must be read with section 60 subsection 7, whether there is a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or conceal or destroy evidence. The court clearly states in C and confirms what was said, that no evidence has been led to the aspect of potential witnesses that could be influenced, as the identity at this point in time, according to the applicants, are unknown. In State v. Longwa, 1979, Volume 4 SA 112D at 113H, the court held there must be a reasonable possibility of such interference and not a mere possibility. At this point in time, the court's got on the one hand denial from the applicants, I will not interfere, I do not know them. And on the other hand, the court does not have any evidence from the state side. So the undertaking from the applicants is in the form of an affidavit. In State v. Bennett, 1976, Volume 3, SAC 652, Cape Division 655, G to H, Judge Voss formulated the test. It appears to me that an applicant has thus far not interfered with investigations. Clearly, the proper approach should be that unless the state can say that there is a risk that he will interfere, not merely he may interfere, that this does not appear to me as a reasonable possibility of such interference. Regarding Section 60, subsection 4D, read with Section 60, subsection 8, where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives of the proper function of the criminal justice system, including the bail system, the state conceded that there was no likelihood of such risk. The court therefore takes the consideration of State v. Yanta into consideration, and the court quotes, in considering this question, the court may take into account the fact that the accused knowingly supplied false information at the time of the arrest or during the bail proceedings. None was proved that this was the case. Subsection 60, subsection 4E must be read with 60, subsection 8A. Based upon the evidence placed before court in this bail application, clearly none of the listed subsections are present and shown to exist. With reference to the aforesaid, the court needs to establish if there is a likelihood that if the applicants were released on bail, that they would either not stand their trial, that they might flee or will flee because there needs to be a likelihood, that there is a likelihood of intimidating the witnesses or jeopardize the proper function of the bail system. In Diale and another 2013, Volume 2, SACR 85 GNP, paragraph 14, it was held that the court cannot find that the refusal of bail is in the interest of justice merely because there is a risk of possibility that one or more of the consequences mentioned in Section 60, subsection 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made. Unless it can be found that one or more of the consequences will probably occur, detention of the accused is not in the interest of justice and the accused should be released. And now the purpose of bail is furthermore, amongst others, to secure the attendance of the applicants before court until this case is finalized. All 10 may stand up. After the court has taken all the relevant factors, case law into account as dealt with now, the court hereby grants bail to applicant number 1, Mr. Booi. You are granted bail in the amount of 250,000 rand. The applicant is prohibited to make contact directly or indirectly with any witness for the state till the matter is finalized. The applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave the Eastern Cape where he resides without contacting the investigating officer, Captain Pekier of Provincial Criminal Crime Investigation. Cell number will be supplied, disclosing full information as to where he would be traveling to, the duration of him being out of the Eastern Cape, and when he would be returned. Applicant 2, Ms. Manuel. Applicant is granted bail in the amount of 150,000 rand. Applicant is prohibited to make contact directly or indirectly with any witness for the state till the matter is finalized. Applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave the Western Cape, where she resides, without contacting the investigating officer, Captain Pekier, of Provincial Commercial Crime Investigation, with cell number which will be provided to you, disclosing full information as to where she would be travelling and when she would return to the Western Cape. The applicant furthermore may not get involved in any other form of criminal activity that may lead to your arrest or charge while the matter is pending. Applicant 3, Mr. Kader. Applicant is granted bail amount of 250,000 rand. Applicant is prohibited to make contact directly or indirectly with any witness or witnesses for the state till the matter is finalized. The applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave the Western Cape, where he resides, without contacting the investigating officer, Captain Pekier of Provincial Commercial Crime Investigation, with cell number which will be given to you, with the full disclosing his full information as to where he would be travelling and when he would return to the Western Cape. Applicant 4, Mr. Mohammed Amot. Applicant is granted bail amount of 250,000 rand. Applicant is prohibited to make contact directly or indirectly with a witness or witnesses for the state till the matter is finalized. The applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave Gauteng, where he resides, without contacting the investigating officer, Captain Pekier of Provincial Commercial Crime Investigation, with cell number will be provided, disclosing full information as to where he would be travelling and when he will return to Gauteng. Applicant 5, Mr. Randall Millens. Applicant is granted bail amount of 250,000 rand. Applicant is prohibited to make contact directly or indirectly with any witnesses of the state till the matter is finalized. Applicant is prohibited to leave the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave the Western Cape, where he resides, without contacting the investigating officer, Captain Pekier of Provincial Commercial Crime Investigation, with cell number providing to you, disclosing full information as to where he would be travelling and when he would return to the Western Cape. Applicant 6, Ms. Brenda Millens. Applicant is granted bail amount of 250,000 rand. The applicant is prohibited to make contact directly or indirectly with any witnesses of the state till the matter is finalized. The applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave the Western Cape, where she resides, without contacting the investigating officer, Captain Pekier of Provincial Criminal Crime Investigation, with cell number which will be provided, disclosing full information as to where she would be travelling and when she would return to the Western Cape. Applicant 7. Applicant is granted bail in the amount of 25,000 rand. Applicant is prohibited to make contact directly or indirectly with any witnesses of the state till the matter is finalized. The applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. The applicant is further prohibited to leave the Western Cape, where residing, without contacting the investigating officer, Captain Pekier of the Provincial Commercial Crime Investigation, with cell number which will be provided, disclosing full information as to where she would be travelling and when returning to the Western Cape. Applicant 8. Applicant is granted bail in the amount of 25,000 rand. Applicant is prohibited to make contact directly or indirectly with any witness for the state till the matter is finalized. Applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. Unfortunately, as there was no indication and proof that you need your passport to travel overseas for work purposes in any form, by letterhead or by employer, that you need your passport passport, the court is not going to grant that request. The applicant is further prohibited to leave the place of where she stays without contacting the investigating officer, Captain Pekier of the Provincial Commercial Crime Investigating Unit, with cell number provided for, disclosing full information as to where she would be travelling and when she will return to the province. Regarding applicant 9, applicant is granted bail amount of 25,000 rand. Applicant is prohibited to make contact directly or indirectly with any witness of the state till the matter is finalized. The applicant is prohibited from leaving the Republic of South Africa for the full duration of the case until it's finalized. Also, this applicant is further prohibited to leave the province where she resides without contacting the investigating officer, Captain Pekier of Provincial Commercial Crime Investigation, with cell number which will be provided for, disclosing full information as to where she would be travelling and when she would return. Applicant 10. Applicant is granted bail amount of 25,000 rand. Applicant is too prohibited to make contact directly or indirectly with any witness of the state till the matter is finalized. Applicant is prohibited from leaving the Republic of South Africa for the full duration of the case up till it is finalized. Applicant is further prohibited to leave the Western Cape where she resides without contacting investigating officer, Captain Pekier of Provincial Commercial Crime Investigation, with cell number which will be provided, disclosing full information as to where she would be travelling and when she would return to court. I've made copies for the state. It will be attached, and for the legal representatives, so that they can show their clients as to what the bail conditions are.
Your Worship, as indicated in the request of the status that this matter be remanded until the 16th of October.
Purpose of postponement, Advocate?
Your Worship, it will be for provisionally for further investigation, but more importantly for joinder of other accused.
More importantly?
For joinder of other accused.
Right. Case is now postponed to the 16th of October for further investigations, as well as adding some co-accused, accused number 1 till 10 in custody, already fixing the amount of bail with the conditions. They are warned to attend court 16/8:30. Wait until their names are called. Conditions are attached to the charge sheet. Yes, I see your client is waving at you, yes. It's going to be better. Right. Got it, gents?